Today we'll explore negligence and liability as they apply to K-12 schools and higher education institutions. School liability is a central issue in a variety of cases, ranging from wrongful death to sexual harassment, and from serious injuries to the complexities of bullying. They're not only headlines, but also influence how we build a safe environment for students, faculty, and community members. We'll learn 4 key factors courts use to scrutinize in school negligence cases: duty, breach of duty, causation, and damage. As educational administrators, you are the frontline defense, the decision maker who can turn those legal principles into proactive actions in your schools. I'll use 2 cases to introduce those key factors of school negligence. Here is the background of the case Achay v. Huntington Beach Union High School District, 2022. Put yourself in the shoes of a school administrator at Edison High, where a routine day turned into a cautionary tale. Achay, a 10th grader, followed her usual schedule. Classes until 2:30 p.m., then up to track practice, a highlight of her day shared with many other students. But on March 29, 2018, a seemingly minor change in routine led to an alarming incident, highlighting critical issues of student safety and campus security. That afternoon, track practice ended 1 hour early at about 4:30. Achay and her friend Sotelo walked to Starbucks and returned about 45 minutes later. This casual decision set the stage for a serious event. On their way back to campus to retrieve her school books from the locker room, they encountered a stranger on rollerblades who was later identified as Mir. Achay found Mir to be suspicious because of his dark clothing and because he made eye contact with Achay, but did not say anything. As Achay and Sotelo walked back to campus, they moved closer to the school fence and away from Mir, who was taunting them. Feeling threatened, Sotelo called another student, Rios, seeking reassurance as they navigated back to the perceived safety of the school grounds. They found Mir in the parking lot. The girls, seeking safety in numbers, stayed near another student, Pace, who informed them that Mir used to be an Edison student. He now attended another high school, and he's kind of weird. The girls, sensing danger, locked themselves in the varsity locker room. Then they finally left the girls' locker room to go to the school's parking lot, where Sotelo's mother was to pick them up. Then the unthinkable happened. Mir, who had been lurking, stabbed Achay, leaving her seriously injured. Achay sued the school district for negligence. Do you think the school district is liable for Achay's injury, and why? Let's look at the first factor of negligence, duty. A special relationship is formed between a school district and its students, resulting in the imposition of an affirmative duty on the school district to take all reasonable steps to protect the student. School personnel owe students, under their supervision, a protective duty of ordinary care, for breach of which the school district may be held vicariously liable. A school district's responsibility includes the duty to use reasonable measures to protect students from foreseeable injury at the hands of third parties acting negligently or intentionally. Foreseeability is determined in the light of all the circumstances and does not require near identical events or injuries. It is not necessary to prove that the very injury which occurred must have been foreseeable by the school authorities. Their negligence is established if a reasonable, prudent person would foresee that injuries of the same general type would be likely to happen in the absence of adequate safeguards. Additionally, the issue of foreseeability does not depend upon the foreseeability of a particular third party's act, but instead focus on whether the allegedly negligent conduct at issue created a foreseeable risk of a particular kind of harm. Schools have a general duty to supervise the conduct of children on school grounds during school sessions, school activities, recesses, and lunch periods. The duty of supervision is limited to school-related or encouraged functions and to activities taking place during school hours. The school district argued that if Achay was stabbed in her chemistry class, then the school district owed her a duty of care. But in this case, the school district argued that its duty to protect Achay ended when her track practice was over and she left the campus for 45 minutes. As a result, the school district did not owe Achay the duty of care. The question is, did the school's responsibility to protect her end when track practice did? Here, the appellate court said no. Just because practice ended, the school's duty did not. Achay was still involved in the school-related activity, so the school was responsible for her safety. Achay was on her high school campus after regular school hours to attend her track practice. Achay was to be picked up after practice in the school's parking lot. At the time of the stabbing, the swimming team was still conducting its practice nearby. So the court held the school district owed Achay a duty of care because she was stabbed while she was on campus during school-related or encouraged functions after school sport. It simply makes no difference whatsoever that Achay briefly left the campus and returned before her ride arrived to pick her up, regardless of her reasons. Another key factor of school negligence is causation. To establish causality, Achay must demonstrate that the school's action or inaction were a substantial factor in causing her harm. There must be a direct link between the school's breach of duty and the injury sustained. She must also show that, in the absence of the school's action, it's more likely than not that the harm would not have occurred. In this case, the school's policy allowed members of the public onto school grounds after 2:30 p.m., as if it were a public park, even though apparently hundreds of students were routinely still on campus participating in after-school sports function. Campus supervisors were on duty only until 4 p.m., but school facilities such as the girls' locker room were left open until 6 p.m. During after-school sports activities, students were generally supervised by a coach, but after a team's practice, there was no supervision. In the 3 years before this incident, there were about 30 safety incidents at the school, but none after 2:30 p.m., which might have given a false sense of security. The key question here is whether the school district took reasonable steps to ensure student safety, especially from potential threats like near during after-school activities. For example, should supervisors have been on duty later, given that the public could access the campus and many students were still present? This is a question a judge or a jury would consider weighing the school's security measures against the potential risk. The school district argued that even if supervisors had been on duty, they may not be able to prevent the incident, which occurred quickly and without warning. However, the fact that Achay and her friends were already scared of Mir suggests that the more proactive security measures may have made a difference. If supervisors had been around, the students may have sought their help, or the supervisors could have noticed and addressed the situation with Mir. As administrators, this case highlights the complexities of ensuring student safety, particularly during less supervised times like after-school activities. It challenges you to think about how your policies and practices align with the duty of care you owe to your students. Let's look at another school negligence case. In the case of CI, the San Bernardino City Unified School District 2022, we have a tragic situation involving a school shooting that poses important considerations for school administrators. In this case, Karen Smith, a teacher at a San Bernardino school, was estranged from her husband, Anderson. On April 10, 2017, Anderson arrived at the school's front office under the disguise of dropping something off for his wife. The receptionist, who knew him as Smith's husband, witnessed him sign the visitor's log as required by school policy, but never asked for identification. Previously, Anderson had been to the school and never posed a threat or caused any problem. Smith never informed anyone at the school or the district about her marital issues, and the school principal never observed any suspicious injuries on Smith. The receptionist therefore allowed Anderson to enter the school building and proceeded to Smith's classroom without notifying her of his presence or asking permission to send him back. Smith's classroom did not have a door. It only had a curtain. Anderson entered the classroom and shot and killed Smith and the student. He then took his own life. At the time of the shooting, the school district and the school had implemented some safety requirements, including San Bernardino City Unified School District policy, which sets forth the registration requirements for a school visitor who are considered outsiders. A school employee's spouse is considered an outsider. The regulation also states, unless otherwise directed by the principal or designee, a staff member shall accompany visitors while they are on school grounds. This means the principal or designee has the discretion to allow visitors on school grounds without being accompanied by a staff member. The school principal testified that her practice and the school's historical policy was to allow teachers' spouses to come to campus if they sign in. She also gave the receptionist leeway to identify or that if she recognized the family members, that it was okay to allow them access to the school campus. While several classrooms, including Smith, did not have doors, the principal never spoke to the district's safety experts about the building design or other unique factors concerning their absence. Both the principal and the school's receptionist confirmed that the door from the front office to the interior of the school had always been unlocked, at least during school hours. 8 months after the school shooting, students and their parents filed a lawsuit against the school district, the school's principal, and the Smith estate, alleging negligence and the dangerous condition of public property. The trial court ruled in favor of the school district, citing unforeseeability of the attacker's action and that the school property was not in a dangerous condition. The Court of Appeals upheld the trial court's decision. A key factor in determining the school district's duty is the foreseeability of harm. In this case, the court found no evidence indicating the school district knew Anderson posed a threat. He had previously visited the school without issue, and Smith, the teacher, had not expressed concerns about her safety regarding Anderson. As a school district employee, Smith had no duty to disclose her marital status of being estranged from her husband, which was not related to her employment as a teacher, especially when she had no concern that Anderson posed a threat to her safety. With hindsight, everything is foreseeable, but for foreseeability in the context of a duty to protect, more than a mere possibility of occurrence is required. In this case, the school district could not have foreseen that a non-trusted visitor, such as a teacher's spouse, would pose a danger to the safety of the school and start shooting on school grounds. Students and their parents also argue that the unlocked front office door and absence of lockable classroom doors constitute a dangerous condition. However, the court found no causal link between those conditions and the incident. Even if the doors had been locked, it was likely that the receptionist would have allowed Anderson access, and there was no evidence to suggest Smith would have denied his entry. The court noted the principal's decision to allow staff spouses on campus without an escort is covered by discretionary immunity as per California Government Code. The law protects government employees from liability for actions taken in the exercise of discretionary duties. School shooting is a tragedy. The court acknowledged the traumatizing violence students and their families experienced, but the evidence presented in court suggested that it was not foreseeable by the school district, and thus imposing a duty on the school district to prevent such an incident would be unreasonable. Therefore, imposing on the school district a duty to ensure that its school is safe for every trusted visitor would be entirely unfounded and unfair. The two cases I introduced today invite you to reflect on your own school's policies and practices. How would you, as an educational administrator, balance the need for an inclusive, accessible campus with the imperative to protect students from potential threats? Feel free to leave your comments below. Thanks for watching. I'll see you next time.